I don't think it's coming through because as you can see, the other Mr.
All right, no, yours is better now. All right. This is, it's from Mr. Cardello. All right. So. All right, and I would just ask if anybody's not an attorney on the case or a party that they remain muted with their camera off. So, Mr. Cardello-Smith, we're getting a lot of feedback from the room that you're in, okay? So, what I'm gonna probably do is mute you until you need to speak, okay?
Yes, Your Honor.
Okay.
Can I say my?
Oh, hold on. I'll go ahead and unmute. Can you unmute? Click unmute. Not work with MDOC. No.
Your Honor, let me add something if you don't mind. My name is.
Let me call the case first. Hold on.
All
right. So Mr. Cardello-Smith, I muted you, so now it won't let you no, there you go, got it. This is in the matter of Derrick Lee Cardello-Smith versus Sean Combs, file number 2024-7362NO. So I have Mr. Hughes. Is it my understanding you filed an appearance on behalf of Mr. Cardello-Smith today?
I filed it last Friday, Your Honor. It's a limited scope of appearance only to supplement any oral argument and other matters. I would add that Mr. Smith is coming into you through protective custody at CL Brooks Correctional Facility, and I think that is why we're getting the feedback. I don't know exactly. I'm not sure.
It's feedback because he's in a cement block room, so I understand that. What is your That might help.
Does that help?
Yeah, quite a bit actually. All right. Mr. Hughes, what is your P number?
36421.
All right. And then, all right, so now I have a host of other people. I know that I do have David H. Fink and Nathan J. Fink appearing, and do I have, yes, David Berg as well, and Calder Burgum appearing on behalf of the defendant. So David H. Fink, your P number is 28235. Nathan J. Fink's P number is P75185. David A. Berg is P83696. And Calder A.L. Burgum is P87203. And Erica Wolf, I did get a notice, but you have not yet been admitted to the Michigan bar, so I will not call you as counsel. All right?
Yes, Your Honor. I have a Pro Hoc BJ application pending for your court.
Yep. Thank you.
And I'm Derrick Lee Cardello-Smith on behalf of myself as the plaintiff on the matter for the record.
Yes, and Mr. Cardello-Smith, obviously Mr. Hughes has filed an appearance with a limited scope.
Yes.
Is that correct with your permission?
Yes.
All right, excellent. All right, so we have.
Your Honor? Your
Yes,
Honor?
sir.
I don't mean to interrupt. It's just there's been some circumstances that have taken place since last week. And I wanted to make sure that you're aware of it as soon as I discover it. Monday, we had the judgment. And then Tuesday, Warden Chris King, Inspector Jensen, and several other staff members pretty much stated to me that they're going to remove me from general population. No legit reason, no misconducts, nothing about the high profile nature of the case, simply because they want to get some green out of me for potential green. They said, if I agree to that, they'll put me back in general population, or otherwise they're going to take me, a level 2 prisoner with no misconducts and no reason to be out of general population. As you can see, I'm in shackles. They're going to take me and place me, and I wasn't in shackles in any of our last court appearances. They're going to place me in either Ionia Bellamy Creek, Alger, or Oaks Correctional Facility, and these are level 4 prisons, to make things harder for me to not only prosecute this case, but also to prosecute my other cases. I'm locked in a room on a floor with a whole bunch of other prisoners that are there for their sanctions, their citations, their misconducts. There's literally no reason for me to be in it, and their reasons are complete lies. I've been in there since Tuesday night at 6:30. Not able to use the phone, none of the level 2 privileges that I earned and hold dear. I just wanted that preserved on the record. And today they also just stated to me an hour ago that they're going to be taking my visitor logs, my phone records, and visitor logs, phone records, and some other documents, and presenting those to attorneys Fink and Berg, and also that they have the ability to alter things and alter documents. And that is something that will greatly interfere and impact this case, should this case go to trial, or should this case...
Hey, don't shut that door. If you shut that door, I get really bad feedback and no audio. So, go ahead, finish up,
They
Mr.
want to
Cardello-Smith.
alter the visitor logs. They want to alter the phone records. They want to alter all sorts of documents to change the outcome of this case in Mr. Combs' favor. And all of these things are completely unethical. They're not legal. I'm a prisoner that was raped by this man's client, sexually assaulted by him, had my money taken from me, and now they're doing, there's a lot of dirty moves that are taking place here at the prison linked to this. I just wanted that on the record, Your Honor.
Okay, thank you. So, Mr. Cardello-Smith, obviously I have no jurisdiction, authority, or control over the Michigan Department of Corrections and their policies and procedures. So I appreciate that. So let's move on to the motion. So we have several motions that were filed. We have, let me get back over my notes, defendant Sean Combs' motion to dissolve temporary restraining order and or preliminary injunction. And then defendant Sean Combs' emergency motion to set aside default and default judgment. And then we have those two motions. So Mr. Fink, Mr. Fink, Mr. Fink, Mr. Berg, and Mr. Burgum, who is going to argue that motion, please?
Your Honor, I'll be arguing the motion. David.
Okay, so at this point, Mr. Cardello-Smith, just to make sure we get a good recording, I'm going to mute you, okay? All right, so David Fink, you may proceed.
Thank you very much, Your Honor, and thank you for hearing this on short
Oh, and I
notice.
also will add, counsel, that we have about 20 minutes. So I will give I read everything, never fear. So you have about 10 minutes, and then I'll allow 10 minutes to Mr. Hughes, okay? And then I'll give you about 5 minutes follow-up. Thank you.
Your Honor, I will say that the magnitude of this matter is such that we may need more than 10 minutes. I will move as quickly as and as clearly.
That's fine, and I can schedule this for another day. My motion doc on Mondays, the docket is 15 minutes per motion, and you had asked for an emergency addition, and so I am limited on the time I can give you so that I don't inconvenience my other clients that come in front of me. If you wish it to be set where, you have a period of time to argue it, we can do that, but rest assured, I really only need you to reiterate what's not in your pleadings or, because I have read them and taken notes.
We'll move as quickly as we can, Your Honor, and we'll be able to determine whether we need more time afterwards. And I will try to speak as clearly as I can. If I'm speaking too fast, I apologize to the court reporter and to the court. And please let me know. First, Your Honor, to be clear, we have filed a limited appearance in this case, and it's limited appearance for the most important issue, which drives everything that we're dealing with here, which is that this court does not have personal jurisdiction over Sean Combs. And the reason is because there has been no proper service in this case. There's no question about it. Now, clearly, we have two different motions. Both motions, though, are controlled by and can be disposed of simply based on one issue, which is the lack of service. That the lack of personal service is everything here. Now, Your Honor, we know that the court is well aware of the rule because, in fact, we have obtained the transcript of the proceeding last Monday. And on that transcript, this court correctly stated the requirement that there must be, that when you're dealing with mail service, which you're dealing with here, under 2.105 sub A, it must be served, it must be return receipt requested and delivery restricted to the addressee. This court recited that appropriately. There's no mystery here what happened. Mr. Combs made a misrepresentation to this court, and we're going to be able to show it. I'm not
Saying Mr.
I am
Cardello-Smith.
so sorry, Mr. Cardello-Smith. If I make that mistake, please correct me. I apologize. Mr. Cardello-Smith made a fundamental misrepresentation to this court, and I'm literally going to be able to show it to you right now. Now, in the pleadings, you may recall that first he claims that he served by mail on May 31st. Then later, he claims that he served on July 6th. But the way that he proved service on July 6th was to show the court a return receipt. Can we share the screen? We can put the return receipt up on, the court will allow us to share the screen.
Sure.
So the first document, if I could do this myself, the first document the court is seeing is exactly the proof of service that the court relied upon, the plaintiff's green card. And I'd like the court to look at this card for just a moment, but we don't have much time. So I'm going to jump ahead and show the court the other card that was filed with the court. This one, as you can see, by the way, let me take just one moment. Yeah, okay, we've still got it. You can put it back up. Yeah, we've got the two cards. If you look on the left, you see the card that the court understandably relied upon. Now, looking at that card, I would point out that the printed name there is, I don't know what it is, but it certainly is not Sean Combs. The signature, I don't know what it is, but it's certainly not Sean Combs. But the card on the left, which was one of the cards the court had in its file that was provided by Mr. Smith, that card has checked off addressee at the top. It says on the left side under summons and complaint, it has the number of the case. And then on the bottom, it's checked off certified mail, restricted delivery. Then on the right, you see where it says signature confirmation and signature confirmation, restricted delivery. Does court see that?
Yes.
Okay. But the card on the right was also filed with the court by Mr. Smith on the same day. It's in the court file. And that card is absolutely identical. You can see it. It's clearly the same card because you see, like in the lower right-hand corner where somebody has scribbled return receipt requested. Look at the odd way that the date says July 6, 2021, but it's got a little funny mark on the top of the one. Who knows? Maybe somebody was trying to write 4. I don't know. But clearly these are the same documents. But the one on the left has been doctored. After this was signed, after the card on the right was signed, somebody went through and checked addressees, certified mail, restricted delivery, signature confirmation, and signature confirmation, restricted delivery. Looking at these cards, there's no way this could have been done in the other order. First of all, there'd be no reason to have taken it and then erased those markings. But if you had erased or whited out those markings, there'd be some showing on the card on the right, and there isn't. The card on the right is the actual return receipt. And apparently, Mr. Smith, who did plenty of other things which we can talk about that show his lack of credibility, but apparently Mr. Smith realized it was supposed to be restricted. And so after he got the card, he checked those boxes and then resubmitted it to the court. That alone establishes he did not serve properly. The court rule couldn't be more clear, and it's very, very clear that he didn't do that here. Now, let's be clear about who we're dealing with, okay? Mr. Smith.
Are you done screen sharing? Because you can remove that if you'd like.
We're done with this particular, we can take this document off, yes.
Thank you.
Mr. Smith resides at the E.C. Brooks Correctional Facility. He's there for a reason. The court knows he's convicted of multiple felonies. He's there for a long, long time. He's also a serial litigant who has been found by the federal court by Judge Lawson in the Eastern District, and we've got this in the record, he has been found to have filed at least 4 frivolous lawsuits. That's before this one. Now, Your Honor, I want to be clear about something. Mr. Combs has denied service in his affidavit very explicitly and very clearly. He's also denied signing the card. But if you look at the card, and I'm sorry, I guess we don't need to pull it up again, but if you look at the card and look at the signature, that is not the signature of Sean Combs. Now, I'm not expecting the court to have memorized Sean Combs' signature, but that signature doesn't say anything like Sean Combs. Now, in this case, Mr. Smith has presented another signature that he claims to be the signature of Sean Combs. As the court may recall, that signature is found on this 11-page document. We'll be showing it to the court in a little while. And that signature is 100% different than this signature. Now, neither one of them are the signatures of Sean Combs, but these are both signatures that Mr. Smith wants the court to believe are Sean Combs' signature, and they are not. Now, Your Honor, with the limited time that we have, I want to be as clear as possible. In his affidavit, Mr. Combs has told the court he didn't get the summons and complaint. He didn't sign a return receipt. He looked at the return receipt filed in this case. It's not his signature. The address on the return receipt is not his primary address. He does not primarily live in Los Angeles. He lives in Miami, Florida now. But Your Honor, and this alone should resolve both cases with both motions, without a proper service documented to the court. He had the burden of proving it. Without proper service documented to the court cannot exercise jurisdiction over Mr. Combs. Just cannot. Now, I'm going to go very quickly through a couple of things here, but I think I need to jump ahead to something else, because the court has heard many lies from Mr. Smith. And only this morning did we confirm that one of them was a lie. And that is at the temporary restraining order hearing, which we were able to observe on YouTube. At that hearing, you may recall that Mr. Smith told you that he was visited at the prison by Sean Combs. He told the court that he gave the court a visitor list, apparently thinking that showing the people he was willing to visit would mean that willing to have visited him would mean that they had visited him, which they don't. We subpoenaed the prison. And that's what Mr. Smith was talking about. We subpoenaed the prison. And just this morning, just minutes ago, actually, we received something which I want to show you on the screen. This is the document that we got from the prison when we said we wanted a list of every visitor that visited Mr. Cardello-Smith at the prison between January 1st and today. Now, as you will recall, when he testified, he told you in the TRO hearing, he told you that 2 weeks before that, and that was some date in August, that 2 weeks before that, not only had Sean Combs visited him, but Sean Combs had offered him $2.3 million. Sean Combs had told him some other things, and supposedly Sean Combs had even said to him that he would not be answering the complaint, as though that's something that somebody tells an opposing party. Your Honor, this is the visitor log that we received this morning from the prison. And as you can see, he has had 3 recorded visits since January 1st. William Proctor, Paul Hughes, and William Proctor. Paul Hughes, as you understand, is his lawyer. And by the way, I'd point out, this was on September 5th. So while the court has been indulging Mr. Smith's shall we say, creative filings, he has actually been being advised by counsel, who's now on the Zoom today with us, on this proceeding with us today. Your Honor, in order to have entered an order, and the reason I'm showing this particular thing to you is that his credibility is relevant. He lied to this court repeatedly, and we have evidence of it, and we've only been on this case for a couple of days. Mr. Smith did not know about this case. Mr. Combs did not know about this case until he saw it in the public media when the default judgment was entered on September 9th. The very next day, we were retained. We filed our pleadings as fast as we possibly could. We got here as quickly as we possibly could once we could put the facts together. And we're getting more facts every minute. Now, Your Honor, the temporary restraining order. The temporary restraining order could not be more improper for so many different reasons, but I'm going to cut to the chase. The most important reason is if you and none of these allegations are true. Mr. Combs denies every single allegation. This is pure fiction, but we don't expect the court to rely on that. What the court can rely on is if every word in this complaint were true, and they're not, but if every word were true, the statute of limitations ran years ago. He couldn't possibly prevail on likelihood of prevailing on the merits. This court couldn't determine that he's likely to prevail on the merits. It's impossible for him to prevail on the merits. He claims all of this occurred in 1997. The most generous interpretation of the statute would be the 10-year statute, which was adopted by the legislature in 2018. The actual statute of limitations in place in 1997 was a 3-year statute for allegations like this arising out of criminal sexual conduct. This claim has been barred by the statute of limitations for years. This occurred 27 years ago. The statute ran at least 17 years ago and probably 24 years ago. And that should be the end of any inquiry regarding likelihood of prevailing on the merits. But if the court wants to go further, the court can look at the completely implausible allegations that this man makes. Here's a man who's been convicted of criminal sexual conduct and kidnapping and who's filed at least 4 frivolous lawsuits in federal court. But look at what he says in this case. And we're going to show the court something very interesting here. He claims in this case that this occurred in Adrian, Michigan. In his pretrial statement, which is filed in this court, he states that the assault occurred in the city of Adrian. Now, the complaint doesn't say that. In the complaint, in the first paragraph, when he refers to the Holiday Inn, he says it's located in, and then the next spot is whited out. Well, as the court might know, there was no Holiday Inn in Adrian in 1997. That building was turned into a Holiday Inn in 1999, 2 years later. It was not a Holiday Inn. And it might have been convenient for Mr. Combs, for Mr. Smith to make that claim. It might have been convenient. But I want to show you something that's a lot more interesting and a lot more troubling and should again be decisive. Nate, can you share the screen? Your Honor, we learned late Friday through a little bit of investigation that Mr. Smith filed an almost identical complaint in Monroe County, and we're showing it right now. It's case number 2024-147784-NO. That was filed. And by the way, we checked the court docket. There's been no action in it after it was filed. Note that it was filed on June 10th, the exact same date that this case was filed in this court. And if you look side by side at the two documents, you can see the way that he has been trying to manipulate this court with his cunning frauds. I mean, it's shocking what he's done here. On the left side, where you see the complaint filed in Monroe County, if you look at the jurisdictional statement, I'm not sure why he put that in. He must have, it's really something when you're doing a divorce, but he put it in and he says he maintained a residence in Monroe County at least 6 months prior to incarceration. On the jurisdictional statement in this case on the right, you see that he said that he maintained a residence in, you see how he whited out county, which whited out Monroe, but that's not all. Can we go to the next page? His paragraph 1 in the complaint. In the Monroe County complaint, he says he was invited to attend a gathering at the Holiday Inn. This is what Mr. Smith wrote, located in Monroe, Michigan. where he says these things occurred. Then let's look down at the Lenawee County complaint. Absolutely identical, with one difference. Invited to attend a gathering at the Holiday Inn located in blank, Michigan. And then, of course, in this case, he lies flat out in a pretrial statement and says it was in Adrian, Michigan. Never tells anybody about the Monroe complaint. Never tells that lie again. He picks his lies to manipulate the court he wants to manipulate. By the way, there's more in common in these cases. Nate, can you show the next thing? In both cases, he files a proof of service. And the proof of service says, as the court will recall, this odd proof of service says that he served the pleadings on May 31st. Obviously impossible. The pleadings didn't exist, at least hadn't been filed in any court by May 31st. But in Monroe County, you can see the proof of service. Here in Lenawee County, check out the top of that document. You see how he cuts and pastes, how he puts in the Lenawee County court rather than the Monroe County court. Otherwise,
so Mr. Fink, as I said, my Monday morning docket is pretty tight. I have a hearing set every 15 minutes. You guys, we appreciate you request emergency hearing. We tried to fit you in, but I am out of time. So I am going to set this right away expeditiously for another time.
Your Honor, I have to beg the court to set aside the TRO. The TRO is invalid.
Mr. Fink, I have a docket that I'm running. I'm going to get you in right away, but I'm not going to inconvenience the other people that are in front of me for you on an emergency hearing. I understand that. So I can, let me see, 11:130. So we can do, I can do 8 a.m. What is this? Hearing. I can do 1 hour tomorrow. That's a post-judgment hearing I have at 1:30. So I can set this for 1 hour tomorrow. Do we think we're gonna need more than an hour?
Your Honor, this is so critical that we'll take whatever time the court can give us. We'll try to give.
Well, my question was, do you need more than an hour?
If we can at least address the temporary restraining order unless.
Mr. Hughes?
We can do it in 1 hour.
Your Honor, I have an important doctor's appointment tomorrow. I cannot do it.
What, do you have the morning available?
The appointment is at 11 a.m.
Okay, how about Wednesday at, ex parte, what about Wednesday?
Wait, Your Honor, a temporary restraining order cannot exist for more than 14 days. Your Honor, this restraining order is a violation of the court.
Mr. Fink,
space.
stop before I hold you in contempt.
I'm sorry.
I am trying to accommodate you as quickly as possible. I am not going to inconvenience the other 30 people that are on my docket this morning. So I am trying to accommodate you. So I can do 11 o'clock on Wednesday. I can do 1:30 on Wednesday.
Your Honor, let me.
I will bump other evidentiary hearings, but I cannot bump my motion docket. So Wednesday, 11 o'clock.
What time, Your Honor? What time? I'm sorry. What time?
11 or 1:30.
Well, we want it as soon as possible, so.
Well, it's 2 days away, 11 or 1:30. What works best for you?
I said 11.
Okay, Mr. Hughes.
That's fine, Your Honor.
So we
Your
will
Honor,
see you back here.
May I respectfully ask the court to revisit just the issue of the TRO? A TRO is not supposed to last for more than 14
days. Now and go to
days.
my other hearings. Thank you very much. So we will see you back the 18th at 11 o'clock. Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
So we will continue this to 9:18 at 11. All right, and I would ask anybody from the media to log off. Thank you. All right, so Ms.
that got a bit, whoa. That got a bit spicy. For those of you that just came in, you might want to rewind it back. Sean Combs, let me take this thing off of here. Sean Combs just filed an emergency motion. David Fink is actually a decent attorney. I went against him a few times. He's in a bigger firm here closer to us. Adrian, interesting fact, nothing really happens in Adrian. I was born in Adrian, Michigan, and it's a very small town and everybody in there is related. So again, like my sister said in the chat, this probably made the front news because I've made the front page a couple of times on minor stuff when I was in Adrian. But nonetheless, as you guys see, Sean Combs filed a emergency motion to set aside the default judgment. His attorney, David Fink, has presented a whole lot of receipts or evidence to basically show that perhaps it was fraudulent. He was litigious. They also showed the actual sign-in log, which I told you guys before will be the telltale. And it looks like all of it was made up. And then it also looks like the one in Monroe. He filed a lawsuit in Monroe, but also he has filed other things of which, like, he's filed things against our governor. Just the other, let me see if I could pull one up on him. Let's see. Let me see if I could pull this up real quick. But yeah, he does have, if you Google him, he is very litigious. I told you guys that before. But she was very, very, I mean, I guess as an attorney, I can definitely appreciate like her being strict on her docket, but I also can appreciate zealous advocacy from Fink because there is a TRO in place that's basically preventing him, basically Sean Combs, from selling any property or assets at this point. So I can appreciate both sides. As an attorney, I can appreciate judges that don't have you sitting there all day long acting like you ain't got nothing else to do. But then I can appreciate his advocacy, even getting, you're going to be held in contempt. But here's actually a recent case that probably wasn't brought up. This was against Dana Nessel. That's our attorney general in Michigan. And it had basically what he did was, of course, it was denied. The grave matter plaintiff's assertions are a typewriter in his possession while a prisoner in the Michigan Department of Correction was taken from him improperly. Plaintiff asserts he was properly in possession of the typewriter, and for various reasons set forth in his pleading, it was taken from him. In his motion for sanction, it does not appear that plaintiff provides citation to any constitutional provision, statute, or court rules in support of his position. In its reply, defendant states that plaintiff is seeking to appeal a decision of the MDOC, and the court does not have jurisdiction to decide the claims he seeks to raise in his motion. The MDOC is not a party to this action. Plaintiff has cited no legal authority in support of his position. For these three reasons, his motion for sanctions is denied. So he was basically asking the court, this is what he was asking the court, a motion to conduct a hearing to determine sanctions, and motion for a temporary restraining order and preliminary injunction with notice of hearing for July 8th of 2024. So this was just 2 months ago. He went to the court of claims and all of his stuff was denied, and it was over a typewriter. Also, I told you guys when we talked about this that he was very litigious, and that when you guys were like, are you going to cover the 100 million? I said, I doubt that the judge is not going to set this aside. Now, after looking at all of this, she probably feels some kind of way. I would assume that it even went this far, but hey, I don't know. We're going to see what evidence he come with. But Attorney Fink was coming with the receipts, as you guys see. So we will be back here apparently on Wednesday to see what the outcome of this is. I know this was a surprise live. I knew on Friday that I was going to be able to get on it and give it to you guys, but I just wanted to make sure wanted to make sure it was going to happen before I told you guys that we were going to do it. So anyways, that's where we at. This is part 1. First of all, let me thank the people that gave the super chats. Boogie 713. I appreciate you, but I wanted to stream it full. This is some juicy ish. Thanks, Pammy Pam. Y'all are welcome. Darlene Burrell, you said thank you for your hard work. Thank you so much. And JoJo, thank you so much for becoming a member. We'll probably be back on some other matters. For those of you that follow the Ernest Williams case, we'll be back to talk about that. So Tracy said, let me lay out my core outfits. Yes, so we will be there for part 2. And of course, thank you guys so much for supporting. Please hit that like button on the way out. And we'll be back at it, y'all. We will be back at it. I'm going to holler at you guys next time. And subscribe to the channel if you haven't done so already. I didn't make it subscribers only or anything. I was come one, come all. So you guys get over here because it's gonna be on subscribers only probably when I do the second part. But you guys have a great day. I'm sure I'll see you guys later on the other matters that we have going on today. Until then, have a great day.